Good day. My name is Regan Mitchell. Me. We are a next generation wealth advisory firm. We are based in Johannesburg, South Africa. I am also a certified financial planner professional and a professional member of the Financial Planning Institute of South Africa. I thought it would be creative and interesting to share with our audience what a last will and testament looks like. We oftentimes we would share the stats concerning the amount of people in our country that don't have wills. At the present moment, they're saying the stats show that about just over 70% of South Africans don't have a last will and testament. And this creates immense administration problems, not only for the master of the High Court, for the family, but besides that, the other consequences that come with not having a last will and testament. uh, More prevalent in our communities is the family feuds that ensues post the death of a loved one. And this can go on for years. And I'm of the personal opinion that this is a social problem because there's no proper transfer of wealth. And there's a delay on a person's assets, or there's a delay on the person's estate, and you find that someone's estate is in limbo for years and years. And that, in my opinion, impacts on generations and generations to come. And what is important in our practice is the concept of preserving generational wealth, the concept of preserving your legacy. And so it is critically important for any person that has an asset, even if it's a bank account with very little money in it, it's important for you to consider drafting a will. And so I thought today I would share with you what a will looks like. A basic will, a simple will. For most people, this is what would apply. And we encourage our clients really to keep their will simple. Simplicity always wins. I must also mention to you that this will doesn't belong to a specific client. This is a dummy client. The ID number is a dummy ID number. Client confidentiality in our practice is critically important, and we will not share our clients' information publicly. So this would normally be the first page of a will. Um, the last will and testament of Boss Lady with the ID number. We work with Capital Legacy. As I said, WealthyMe is my company that I founded and started in 2019, which is over 2 years old. And our practice is growing, and we're really helping a number of clients with their financial planning needs. And one of those being estate planning. And your will is a critical component of your estate plan. Your will doesn't make up your entire estate plan. It is a component of your estate plan. So this is what a will looks like. These are some of the clauses. So your first clause would normally be a revocation clause where you revoke all previous wills, and you basically declaring that this will is your last will and testament. All previous wills are revoked by you signing this will and dating this will. Clause number 2, last wishes and special terms. You could decide to be buried, you could decide to be cremated. You don't necessarily have to specify. You can leave that up to your family. You could also decide and nominate to become an organ donor. Many people find themselves in hospital needing organs, and you could be a saving grace to someone, and you can specify that in your will. Clause number 3 would deal with bequest and legacies. In this case here, there's a special bequest to her mother A mum will inherit a property at 523 Douglas Drive in Bryanston, and there's a mum's date of birth, and that is 100%. And then the residue of her estate, whatever other property she has, investments, businesses, the residue of her estate is then bequeathed, um, 40% to a child, 40% to other child, and 20% to a mother. Now you would notice it goes um, into trust for the children. Why? Because both kids, Star Lady and Sunshine Lady, are minors, and minors can't inherit property. So whatever minors inherit will go into a trust if you have set up a will. If you don't have a will, whatever your kids inherit from your estate will go into the guardian's fund, the government's guardian's fund. I'm not sure how many people would love for government to administer their estates and whatever their kids inherit. Personally, for me, I would rather want to have control over that and decide who becomes the trustees of my estate for the benefit of my kids. You can also, according to clause 4, nominate alternate beneficiaries. Alternate beneficiaries, if in this instance boss lady and both her kids pass away at the same time, a mum will be 100% beneficiary of her estate. Then you have signatures. You have a witness 1, witness 2, and the testatrix, which is a female. A testator is a male. When you're signing your will, you need to have both witnesses present. In South Africa, the law states that if someone is over the age of 14, they can witness your will simply because they would be able to testify in a court of law. So it is important when you sign your will that both witnesses are present when you sign your will. We also have a clause that stipulates the conditions of the children's trust. One such important condition is at what age will the assets in the trust vest into the name of the kids. In this case, boss lady nominated age 24 as the age trust assets need to vest in the names of her children that she leaves behind. And so these are some of the conditions of the children's trust. Then clause 7 speaks about a bit about the responsibilities of the trustees that are nominated to manage the trusts that are created in terms of the client's will. So when you're creating a, a will via your will, when you're creating a trust via your will, it's called a testamentary trust. If you set up a trust whilst you are alive and transfer assets into that trust, it is referred to a living trust or an inter vivos trust. Interesting, right? Clause number 8 deals with inheritance exclusions. This is normally to protect your estate or whatever your kids or whoever inherits anything from your estate from marital regimes, more specifically so where there is an accrual or where there is community of property, mostly community of property. So if your kids inherit from your estate and they do get married one day, and let's say your child gets married and your child's living in your house and they decide to get married in community of property, that property that your child inherited will be excluded from the community of property estate just by virtue of clause number 8. Clause number 9 speaks about appointment of guardians. When you have minor kids, it's important that in this case, boss lady is single, she doesn't have a husband, so she needs to have a guardian for her kids. And in this instance, she nominates her mum as the guardian of the kids. And it's important to nominate guardians whom you trust, guardians whom agree to be guardians of your kids, because guardians are simply a proxy of yourself. They're an extension of yourself. So you need to make sure that there's an agreement or there's a understanding of the abilities of the guardian that you would be nominating. So this particular person will work closely and will be in communication with the trustees that are managing the assets. So let's say there's cash in the trust, and the trustees need to pay school fees, and the trustees need to make sure the kids have stationery and all of these things. That will be in a consultation with the guardian of the kids. Clause number 10 deals with joint assets. So if there's an inheritance where children jointly own that asset, the clause basically just highlights and makes mention of the importance that those kids or the ones that are inheriting need to decide how they're going to deal with that joint asset. Clause number 11 would deal with collation. Collation simply excludes any assets from the estate and the winding up of the estate, where in this case, if boss lady gave one of the kids a car and did a change of ownership on that car while she was alive, and upon her death, that car will not form part of the the bequest and the legacies. That car will belong to that child and it won't be brought into the equation. Clause number 12 deals with the appointment of executors and trustees. When you draft your will, you have the, the right and you have the privilege to nominate who you'd like to have as the executor of your estate and who you'd like to have as the trustees of the trust that are created for your kids. And then clause number 13 would deal with the powers of the executor and the power of the trustee or the trustees. And there are some of the clauses regarding that. And then you have to date the will. The witnesses' names have to go in here. And you have to sign. Where was it signed? What date and which year? That's your will. And then you can also nominate to have a living will attached as an addendum to your will. A living will is just a document or addendum um, that makes matters easy for your family if in the future you find yourself being held alive artificially through machines and doctors have to consult with your family, and doctors would recommend to switch off the machines because if we keep you alive for much longer, it might take months, and the cost of keeping you alive in an ICU unit, your medical aid may run out, the family may become liable for those costs. In other cases, the the doctors may say that this person, would become um, incapacitated completely, like, in some instances they refer to it as a cabbage. A living will is a document that your family, and this is important that you discuss it with your family and that they know you have a living will, is a document that needs to be pulled out in a situation like that, and that relieves your family from the burden of making that decision to switch off the machines or to keep the machines on. Because in moments like that, you have um, you have opposing views. One sibling might say, no, keep the machines on. The other may say, no, switch it off. The parents may say, no, keep it on. And, the kids say, no, switch it off. So you don't want to have your family, in that difficult situation. In that case, this makes it easy for the medical professionals to decide what happens in a situation like that. So this is some of the basics, the basic clauses, the most important clauses to have in your will, and to get this thing signed and witnessed, and get it into safe custody. Bob's your uncle. I hope this has added value, or at least shown some light, and I hope that I gave you some insight. And if you guys do need help with getting your last will and testament drafted, you can reach out to us at www.wealthymefs, F for financial, S for service, .co.za. You could also, you know, connect with us on social media platforms, on Facebook, on Instagram, on Twitter, YouTube, LinkedIn. You can just search for Wealthy Me and you will find us. Thank you so much for tuning in.